Lord, could I just pick up a couple of loose ends from this morning? Excuse me. My Lord Clerk suggested early on that if factual matrix evidence is admitted, then a contract might be interpreted one way in a dispute between the parties and in a different way in a dispute between non-parties, as which there were, I think, three things I could have said. One is that is a feature that is present in relation to any situation where factual matrix evidence is admitted in a dispute between parties. The second, which in a sense is part of this first point, is that it would be a problem that would only arise if the third parties were unable to have access to the evidence of the factual matrix which we are seeking to adduce in this case. And the third point is that on the facts of this case, it seems difficult to imagine how a dispute involving non-parties could arise in relation to the meaning of this contract. The fact of the contract might be of interest to some, but the meaning of the contract, it would seem, is unlikely to give rise to third-party disputes. My Lord Sir John Dyson asked if the rationale for admitting evidence of the contract or for the purposes of rectification had been articulated in the way I had suggested. I took you shortly afterwards to Cuts and Head. We would, for what it's worth, also mention that this seems to be how the judge at first instance in this case saw it at paragraph 28 of his judgment. My Lord Robert Walker invited my attention to the case of Tomlin on this issue. Having looked at that again over the short adjournment, I wasn't proposing to take you back to it simply for this reason, that one of the strange features of the Tomlin case is that it appears to have been common ground between the parties that if there was an agreement, it would be admissible. The dispute in that case was whether there had in fact been an agreement. Because, as your Lordship may be, it's just for your note, it's bundle 3 at tab 43.
You say take us back to it. I'm not confident of taking us to it at all.
No, I meant back in the sense that some of you have obviously been looking at it.
Are we going to look at it or not?
I wasn't going to take you to it simply because I don't actually think it takes matters very much further. I mean, for information, if it's not in the forefront of your mind, what had happened was a personal injury action in which there were without prejudice negotiations, and it was subsequently argued that there had been an agreement on liability, that liability would be split 50-50, but no agreement on quantum. And the question was whether the matters that had emerged in the course of without prejudice negotiations, supposedly evidencing the contract agreeing liability 50-50, were admissible in evidence. But actually, the case wasn't really argued on the question of whether or not they were admissible. It appears to be in common ground that if there was an agreement, it would be admissible, because otherwise it couldn't be enforced. And it most clearly appears at pages 1385 to 1386 that was common ground in that case. So,
what's the tab number?
I'm sorry, it's bundle 3 at tab 43. So there wasn't any need to articulate the rationale for admitting evidence of the contract itself, because it was common ground that if there was a contract, it would be admissible. The dispute in the case was whether there was in fact a contract between the parties, because one side was saying, well, no, we were negotiating a package settlement, and we only got halfway because we only agreed liability, we didn't agree quantum, so there wasn't a contract. And the other side was saying, no, we did agree a contract on liability, but we didn't agree quantum. So the dispute was not, is a contract admissible, but was there a contract? And so for that reason, that case doesn't, I'm afraid, contain any sort of articulation of the rationale for admitting a contract. Finally, the last sort of tail-end point from this morning, my Lord Simon Brown asked what the position would be under my first argument if there was an item which could be described both as part of the factual matrix and as an admission. As to which there seem to us to be possibly three responses. The first is the one given by my Lord Phillips, is that at the moment we have found it difficult to to conceive of how the same item could be both at the same time. So conceptually, we find it difficult to imagine how the situation would arise. But secondly, if somebody else's imagination is better than mine, then the answer would be one of two things. Either the court could admit that item as relevant to interpretation, but treat it as being inadmissible as an admission, and simply not allow somebody to rely on it as an admission against liability. Or, if for whatever reason that possibility was just not practicable, then the court would be faced with a balancing exercise between competing public interests. The competing public interests being, on the one hand, correctly understanding what the contract was, and on the other hand, running the risk of discouraging parties from negotiating openly in the course of without prejudice. So those are the responses we would offer to that hypothetical.
But isn't an admission only relevant if no agreement's reached? So, I mean, the Muller, Lord Justice Hoffman explanation was that this is the only purpose of without prejudice, to protect admissions pending an agreement.
Yes.
So once one's got an agreement, that aspect of without prejudice goes, doesn't it?
Yes.
And if the admission is a fact as well, for example, I don't know, it might be that particular yard belongs to me. It could be that was a contentious issue in the litigation, but it was also relevant to construe the agreement to compromise the legislation. And the admission ceases to be prejudicial, it just disappears as relevant factor, yes. And the fact remains to construe the agreement.
Yes. Well, that may well be the answer. In what your lordship is in a sense that line of reasoning might actually be part of my first answers. That in reality, it would be difficult to have a situation where there would be an objectionable admission, which was at the same time a relevant part of the factual matrix.
Well, I mean, you may well be right, but I mean, the range of possibilities is so enormous. I mean, you could have a dispute, and then A could say to B, without prejudice, I recognise, although I shall never say so in court, that actually I probably owe you £50,000. Okay. Then they reach an agreement which has nothing to do with paying £50,000 or any other sum of money, and they say, right, well, we'll bury that, but instead we'll have an agreement for the future, and the agreement for the future will be this and that and the other, and it may be an important background fact against which to construe it and against which to construe, whether it's still possible that nothing at all will be paid by one party or another, the fact that he did actually admit to owing £50,000 was something, that would colour the likelihood of a particular construction of the actual settlement agreement. I mean, everybody has done far more contractual cases than I have, but that sort of thing surely can arise.
Well, as I say, my Lord, if it arises in a practical case, then there are two possible solutions. One is that the material is admissible for one reason, but is not to be held as an admission against liability. It's admissible in relation to interpretation, but not as an admission that the person owes £50,000. The alternative, if that is not possible, if the two are inseparable for some reason, then the court is faced with a balancing exercise, which is my second line of argument.
So we're taking it would be relevant as the fact that it was said, but not the truth of what was said.
Exactly. Lord, so I was in the midst of our accumulation of factors which militate...
Could I just ask you one question arising out of Unilever and the passage from my Lord Walker's judgment at 2448, where he says that the without prejudice rule is founded partly on public policy and partly in the agreements of the parties.
Yes.
Now, what's your submission about that? Do you accept that analysis? I mean, what role does the agreement of the parties have?
The way we have put it in our printed case, and I won't say more than this in opening, because we don't understand how the case is put against us. The way we put it in our printed case is to say that we do not understand how contract can be regarded as being anything other than a trigger for making the privilege available. It can't define the scope of the privilege. Now, if I can put it in a nutshell, there is the privilege of without prejudice. It arises either because the parties use the expression without prejudice, or it arises because the court infers that the negotiations were not intended to act as admissions against interest. So in that sense, it is founded on contract, in the sense that whether the privilege is triggered is partly a question of identifying the parties' interests. But the scope of the privilege cannot be defined by contract, because you can't contract out of the court's assessment of what is admissible evidence.
So the parties might agree that this is a without prejudice negotiation.
Or they can agree it's open.
Or
So
they
in
can
that
agree it's
sense,
open.
they have negative control over whether the privilege is
But it
available.
remains to be seen what's meant by a without prejudice
Yes.
negotiation, or what the effect of it, and that depends upon all the other factors.
Yes.
Is that right? Yeah.
There's also a distinction, isn't there, which David Vavver draws in his article, which I referred to in Barclays Bank and Rashid, between situations where someone is attempting to resolve a dispute and other situations in which the words without prejudice are quite often used, where there's no dispute, and then the matter is purely one of contract.
Absolutely, yes, yes, indeed. The point we had reached was that I was enumerating the various factors that militate in favour of the balance falling in favour of admission. We had dealt with relevance. I'd been addressing your lordships on the question that these are facts, not admissions against interest, and I was going to remind you of the passages I have in fact already read, which repeatedly identify the desirability of not throwing back an admission in somebody's face as being at the heart of the privilege. I've already read the relevant passages, and I won't go back to them, but could I just collect them and remind you now? Scott paper, which is bundle 2, tab 39, page 156. Rush and Tompkins, bundle 2, tab 35, page 1300. And the Law Reform Committee's report, bundle 3, tab 63, paragraph 34. As I said just before the short adjournment, we're not trying to reopen the point that my Lord Justice Robert Walker dealt with in Unilever. We're not saying that if it's not an admission, therefore it is admissible. But what we are saying is that the fact that it is not an admission is a relevant factor to be taken into account in striking the overall balance. And we say that, again, it was a point we were toying with just before the short adjournment. We say that because factual matrix material is not throwing back an admission in somebody's face. It is simply adducing evidence blind as to who it assists and blind as to its source. It is simply what it is, namely part of the factual matrix in which the contract was made. The third factor on which we rely as being relevant to the balancing exercise is that what we have here is a concluded agreement. The admission of the evidence in this case only arises precisely because the without prejudice negotiations have fulfilled their purpose. The purpose being to encourage out-of-court settlements. That is what happened in the June 2008 settlement agreement. And it has often been said that the point, or the principal point, of the without prejudice privilege is to ensure that things said for the purpose of settlement are not thrown back in somebody's face if a settlement is not achieved. Now, I quite accept that Rush and Tompkins goes somewhat further, and I'll deal with that in a moment. But just to build up the picture, again, we have the Wever article, which deals with this, bundle 3, tab 58, pages 91 to 92, and if I can just use that as a shorthand rather than going to a whole string of authorities on the subject, bundle 3, tab 58, pages 91 to 92. In the very bottom of page 91, he refers to an earlier decision in the mid-19th century, the treatment of the rule as one involving mainly personal construing words without prejudice given. The stamp of approval in the Chancery Court of Appeal in River Steamer Mitchell's claim, where Lord Justice James arguendo said, does not without prejudice mean I make you an offer. If you do not accept it, this letter is not going to be used against me. In the same vein, Lord Justice Mellish concluded, now if a man says his letter is without prejudice, that is tantamount to saying, I make you an offer which you may accept or not as you like, but if you do not accept it, the having made it is to have no effect at all. And then similarly, just below that quotation, by the end of the 19th century, the doctrine of stare decisis had almost irretrievably fixed the approach to the scope of the express without prejudice rule as involving an exercise in semantics under the guise of a search for the party's intention. Lord Justice Lindley's judgment in Walker and Wilshire contains the classic and most cited exposition of the triumph of semanticism. What is the meaning of the words without prejudice? I think they mean without prejudice to the position of the writer of the letter if the terms he proposes are not accepted. If the terms proposed in the letter are accepted, a complete contract is established, and the letter, although written without prejudice, operates to alter the old state of things and to establish a new one. And then reference is made to in re dentri ex parte Holt, and the quotation at the bottom of the page, it may be that the words without prejudice are intended to mean without prejudice to the writer if the offer is rejected. But in our opinion, the writer is not entitled to, and so on. So those are the various authorities, and again, one sees the same thing emerging, you may recall, from the way the Law Reform Committee put its summary of the position, which is tab 63, at paragraph 34, in the second half of paragraph 34, potential litigants may be inhibited from embarking on negotiations for a settlement which normally calls for mutual concessions on each side unless they can be assured that what they say or offer in the course of the negotiations will not be used against them in the subsequent litigation if the negotiations fail. And the same point is made at the top of the next page. Any party is entitled to make an offer of compromise, for which he can claim a privilege if the negotiations initiated by his offer ultimately fail. And so running through these cases is that consistent theme, and we see it repeated slightly more recently in one case we haven't looked at, which is a dispute between the two chocolate companies, Lindt and Nestles, which is bundle 1, tab 10. Again, the facts don't matter, but Sir Robert McGarry's decision, page 288, line 39, towards the bottom of the page, from the authorities put before me by Mr. Prescott, it seems plain that the courts favour the protection of discussions which take place between actual or prospective litigants with a view to avoiding the expense and burden of litigation, and are very ready to hold that discussions made with this purpose are inadmissible in evidence. Men ought to be able to attempt to buy their peace without prejudicing their positions if the attempt fails and hostilities break out or continue. So again, we submit that one of the key elements in the without prejudice privilege is the question of whether or not the attempt has failed, in which case the without prejudice privilege retains all its vigour, or if the attempt succeed, in which case there is a new world in which an agreement has been reached, and to a substantial degree the privilege has served its purpose.
The underlying premise of all those passages you've quoted appears to be that the relevant relationship between the parties is the relationship of the dispute, and the concern is about being prejudiced in relation to that dispute.
Yes.
A situation which simply isn't covered is that you might have two parties who are in a long-term commercial position with all sorts of different contracts concluded between them or going to be concluded between them. And these cases tell you nothing about what the position would be if in some quite independent subsequent contract there was a relevant issue that arose out of discussions between them in a previous, in relation to a previous dispute.
My Lord, yes. Well, if I can make two responses to that. That is why, first of all, we submit that what is relevant here is that the dispute, and this is going to be what the next point I make, that the dispute here arises in relation to this settlement agreement. It is not some other dispute in relation to some other aspect of the commercial dealings between the parties, in relation to which we're then trying to take advantage of something that was said in these negotiations. It is a dispute only about this settlement agreement. The second thing I was going to say is that the point you've just identified was, I think, at the heart of Rush and Tompkins, which I was just about to go to, because I'm sure my learned friend would wish to rely on this. Rush and Tompkins, you may recall, it's bundle 2 at tab 35. This was the case where the plaintiff had settled with one defendant, and the other defendant was seeking disclosure of the without prejudice negotiations. And what was urged on the House of Lords there was that as between the plaintiff and the non-party, that is the second defendant, the privilege no longer existed. And what Lord Griffith says at page 1300, letter G, he says, I cannot accept the view of the Court of Appeal that Walker and Wilshire is authority for the proposition that if the negotiations succeed and the settlement is concluded, the privilege goes having served its purpose. In Walker and Wilshire, the Court of Appeal held that it was not permissible to receive the contents of a without prejudice offer on the question of costs, and no question arose as to the admissibility of admissions made in the negotiations in any possible subsequent proceedings. There are many situations where parties engaged upon some great enterprise, such as a large building construction project, must anticipate the risk of being involved in disputes with others engaged on the same project. Suppose the main contractor, in an attempt to settle a dispute with one subcontractor, made certain admissions. It is clear law that those admissions cannot be used against him if there is no settlement. The reason they are not to be used is because it would discourage settlement if he believed that the admissions might be held against him. So again, that perfectly clearly re-emphasises the purpose of the privilege that underlies this whole area of the law. But it would surely be equally discouraging if the main contractor knew that if he achieved a settlement, those admissions could then be used against him by any other subcontractor with whom he might also be in dispute. The main contractor might well be prepared to make certain concessions to settle some modest claim, which he would never make in the face of another far larger claim. It seems to me that that's another illustration of the sort of buying your peace line of reasoning. It seems to me that if those admissions made to achieve settlement of a piece of minor litigation could be held against him in a subsequent major litigation, it would actively discourage settlement of the minor litigation and run counter to the whole underlying purpose of the without prejudice rule. I would therefore hold that as a general rule, not a universal rule, as a general rule, the without prejudice rule renders inadmissible in any subsequent litigation connected with the same subject matter proof of any admissions made, and again I would emphasise admissions is at the heart of this, in a genuine attempt to reach a settlement. It of course goes without saying that admissions made to reach settlement with a different party within the same litigation are also inadmissible, whether or not settlement was reached with that party. So his lordship is clearly there saying, and the rest of the House agreed with him, the fact that a settlement has been reached does not destroy the without prejudice privilege of itself. But what, in our submission, Rush and Tompkins cannot be invoked as authority for the proposition that the fact that there has been a settlement agreement is therefore irrelevant as a balancing factor in deciding whether or not without prejudice material should be admitted into the trial process. It's not saying it's never relevant. The most it is saying is that as a general rule, the without prejudice privilege doesn't disappear simply because there has been a settlement agreement. And your lordships will be aware that that was being said exclusively in the context of a claim by a third party who was not party to the settlement agreement in question, seeking to pry into, in relation to a different issue, what was said as between the plaintiff and the first defendant with whom he was settling. And so what we seek to say in relation to Rush and Tompkins is that it is not authority for any general proposition that the fact of a settlement is an irrelevant factor in balancing whether or not to admit material. What it is authority for, what the actual ratio is that the privilege is not lost as against an outsider to the agreement simply because two parties have reached a settlement. That is actually the ratio of the case. And it does also, and we would submit this is strictly obiter, say that as a general rule, the without prejudice privilege continues to render inadmissible any subsequent litigation connected with the same subject matter, even as between the parties.
It's a different kind of animal. Would it follow logically from this that correspondence forming part of the without prejudice negotiations would be privileged against disclosure?
Yes.
I think it would, wouldn't it?
No, absolutely. And in fact, strictly speaking, this was a case about disclosure. It wasn't technically a case about admissibility. Your Lordship will see that from page 1298 at letter B, where Lord Griffiths, giving the lead speech, says, "My Lords, this appeal raises a novel point on the right to discovery of documents." So that is actually what the issue was, strictly speaking, before the court. It wasn't, in fact, a question of admissibility as such. And secondly, it was not a question of admissibility as between the parties to the settlement agreement. So that is the third factor we say is relevant, namely there has been a concluded agreement. The fourth factor, and I've already anticipated this, is that unlike Rush and Tompkins, this case that you are concerned with is a dispute between the contracting parties. It's not a situation where some third-party busybody is trying to find out and take advantage of what A said to B. This is plainly a case where A already knows what A said to B, and vice versa. And the question is simply whether material which is already available to both of them should nevertheless be excluded from the trial process. And as I say, we're not relying on this point alone. We're not just saying because it's a dispute between the parties, therefore it is admissible. We are saying that unlike the position that Lord Griffiths was concerned about in Rush and Tompkins, where you may be prepared to settle, you may be prepared to make a concession in relation to some claim with a small fry, which you wouldn't want visited against you in relation to a claim by some bigger fish. That is not this case. This is a case only about the admission of material as between the parties to the dispute. And that was, I think, really one of the main points that moved Lord Justice Ward in the court below in this case to express the dissent that he did, where he said at paragraph 39, which I think captures the whole of his view, and with which we would invite the Lordships to agree. It's page 17 of the appendix. Page 17, paragraph 39, he says, "I'm not for a moment suggesting that relevance alone displaces privilege. That would obviously be wrong. It was rejected in Offulo and Bossert, where the offer to purchase was clearly relevant but not properly held inadmissible, because it was a statement in the course of negotiations which didn't result in agreement. if the very purpose of clothing the negotiations with privilege is to facilitate in the public interest the settling of disputes by compromise, then once that purpose has been served, there seems to me to be no justification for continuing to wrap the negotiations in this cloak of secrecy. Again, I don't want to take this too far. That I would be prepared to lift the cloak as between the parties to the negotiation is no justification for the peeping toms outside the negotiations, like the subcontractors in Rush and Tompkins, to sneak a look at what was happening beneath the cloak. But if one is allowed to lift this at all, it should be lifted high enough to see in all its raw detail the truth of what previously was, what I think remained unseen.
Was to remain unseen.
Was to remain unseen, yes, I'm sure that's what it should say. And then Walker and Wiltshire is quoted, and then his lordship says, I repeat, the limitation I impose on that rule, it applies only where a new order between the negotiating parties has replaced the old, where compromise has been reached, the purpose has been served, and the inhibitions fall away. So, I mean, if my Lord Mounts, if I didn't make clear, that's page 17 of the appendix,
yes,
Lord Justice Ward.
Yeah.
Sorry. The final factor, the fifth factor, which we invoke as weighing in the balance in favour of disclosure, is that the dispute here is over the interpretation of the settlement agreement. And for the reasons we've already explored, we submit that public policy is clearly firmly in favour of admitting the material because it puts the court in the best position correctly to understand the contract according to its intended meaning, and it will avoid the position that would arise if the court adopted double standards for without prejudice contracts and open contracts. So in that sense, my Lord, what we would urge under this heading is that we are not inviting the court to adopt some special rule applicable only to settlement agreements made following without prejudice negotiations. All we are asking for is the application of exactly the same treatment as would be available in relation to the interpretation of any other kind of contract. And again, we would emphasise that this doesn't cut across the concerns expressed by Lord Griffiths in Rush and Tompkins, because as we saw a moment ago, his concern there was very much that something said as between one party and another to a settlement agreement for the purpose of that settlement shouldn't be thrown back in his face in relation to a subsequent different dispute. But as I say, that's not the consequence of the result which we're urging on you. What we're saying here is simply that it is a relevant factor to be added to all the others. That this is one of those cases in which the balance falls in favour of admission. And so, in conclusion on this second point, we simply say that if contrary to our main arguments, the court considers that there is competing public interest pulling in either direction, the balance ought to fall in favour of admission, notwithstanding that the material emerged in the course of without prejudice negotiations. The third line of argument I needn't dwell on because really, in a sense, it's just an extrapolation from what has gone before. The third line of argument is to say, well, simply that in a situation, in any situation, leaving aside the facts of this case, in any situation where a settlement agreement has been reached, the public policy requiring the exclusion of evidence of without prejudice negotiations as between the parties to that agreement has been spent, and that thereafter all such without prejudice material is admissible as between those parties in any subsequent dispute between them relating to the settlement agreement. As I say, that's not a necessary part of our case, and we simply offer it as a sort of a possible way forward in relation to this area of the law, which is bedeviled with a number of different decisions, not all of which are easy to reconcile with each other. That then leaves the two subsidiary points on estoppel and remoteness.
That proposition that you're obviously putting forward as something wider than the second proposition.
Yes. Well, the second proposition is purely fact-based. We're just saying
I
on the
appreciate
fact.
it is. I appreciate it is. But which of the 5 factors does it actually ignore? You said there are 5 factors on the facts of this case which say if there's a balancing exercise, the public interest in the court getting the right answer should outweigh the postulated countervailing public interest. Which is left out of account in the third wider proposition?
Well, the third wider proposition would not require one to prove, for example, that the material, except insofar as the test of relevance is appropriate for any disclosure, but the first point we make is relevance to the interpretation of the agreement. Material could be adduced that goes to an issue other than interpretation.
Like what?
Oh, Lord, could I? Yes. It may be that they do overlap entirely.
It's not overlapping. I wonder if they coincide.
Yeah.
Well, you could have a formal written agreement which referred, say, to the employee without any definition of who the employee was. And you would then have to go to the negotiations to identify who that person was. That's not really interpretation, is it?
No. I'm grateful. I'll think about that overnight.
Why is it not interpretations?
Can't understand it.
Well, it would be interpretation if there were 2 Mr. Smiths and you wanted to know which it was referring to, wouldn't it?
Yes.
Look at which they were discussing.
Yes. It could well be, my Lord, yes. Could we just think about that one a little further and come back to your Lordship on it?
Backbone. Telling you to do that.
Estoppel. I can deal with both estoppel and remoteness quite lightly because we're now well familiar with the legal principles. Just to put the matter in context, the pleading of estoppel is in the what is now, as I say, the re-amended defence and counterclaim at paragraph 18.1.1a, which is page 99 of the appendix. Just to put that in place, in its amended reply in defence to counterclaim, Oceanbulk has denied that all the transactions were in fact sleeved. The defendants will say that for the reasons pleaded in paragraphs 18.1.1 above, Oceanbulk is stopped from denying that the swap agreements Oceanbulk had entered into with the defendants were sleeved transactions. Alternatively, Oceanbulk is stopped from denying that in negotiating and entering into the settlement agreement, the parties were proceeding on the common assumption that they were sleeved transactions. Now, just as a preliminary point, my lords, there are certain passages in the respondent's printed case which seek to pour a certain amount of scorn on our pleading of estoppel, but the fact is that is not a paragraph that has been struck out, and there was no, indeed, it was the very hearing at which the strikeout application was made that the judge at first instance gave permission to amend to add that pleading. So that pleading is part of the trial process, and the only question that is now live is, well, what evidence is admissible in relation to that pleading of estoppel? We would also just wish to point out that my learned friend's printed case is not entirely accurate when it says at paragraph 61, I don't ask you to turn it up, but he says the estoppel is not relied upon to prevent the respondent from denying the truth of the alleged statement. In the middle of paragraph 61, he says the estoppel is not relied on to prevent the respondent from denying the truth of the alleged statement. Indeed it is. That is exactly what the words I just read you say. The defendants will say that Oceanbulk is estopped from denying that the swap agreements Oceanbulk had entered into with the defendants were sleeved transactions. Alternatively, Oceanbulk is estopped from denying that the negotiation and entering into the settlement agreement the parties proceeded on the common assumption that they were sleeved. So what we're simply saying in this estoppel argument is, well, these things were said by Oceanbulk representatives. Either they're true, in which case they unquestionably form part of the factual matrix, or they are untrue, in which case the respondent is estopped from taking that point, essentially. And so we are, in that sense, we are indifferent as to whether the statements were true or not. We certainly believe them to be true, but as I say, if they're not, we fall back on the estoppel argument. So far as the law is concerned, given that we have at trial an issue as to whether or not an estoppel arises in this case, the question simply is, well, what is the evidence that is admissible in relation to it? So far as authority is concerned, we can go very quickly to three cases which establish as a matter of principle that without prejudice material can be admitted in relation to pleadings of estoppel. And the first is Hodgkinson and Ward's Mobility, which is Authorities Bundle 2 at tab 22. This was a decision in which it arose in the context of an account being taken, an inquiry as to damages. What had happened was that an interlocutory injunction, had been granted in the action based on allegations of passing off and trademark infringement. When the action actually came to trial, it failed. So the defendant then asked for an inquiry as to damages. The plaintiff tried resisting the payment of damages on the grounds which had not been pleaded that the defendant was also in breach of copyright. And there was a dispute as to whether or not the plaintiff was entitled to take that point. The relevant judgment of Mr. Justice Neuberger, as he then was, started at page 182. And 189 is where the relevant passage begins. You see it's sidelined towards the bottom of 190. The whole section on without prejudice starts at 189. The relevant passage is at 190. The second argument raised by the plaintiffs is that it would be wrong for the defendant to be able to hide behind the cloak of the correspondence being without prejudice in circumstances. Sorry, I should have said that one of the things that was being said was that there had been some without prejudice negotiations in which the possibility of a copyright action had been floated. And so what the second argument raised by the plaintiffs is that it would be wrong for the defendant to be able to hide behind the cloak of the correspondence being without prejudice in circumstances where the defendant put forward suggestions or statements upon which the plaintiffs relied, and reasonably relied, in acting as they did. As a matter of principle, it seems to me that even where a party can, in principle, rely on correspondence being without prejudice on contractual as well as public policy grounds, the court will not allow him to do so if it is satisfied that it would be unconscionable. So far as the public policy ground is concerned, it seems to me self-evident that just as much as it is in the public interest that parties should feel completely free to negotiate under the cloak of without prejudice, so it is in the public interest that they should not be able to use the protection of without prejudice for the purpose of unambiguous impropriety. An expression here identifies the source. Equally, so far as the contractual ground is concerned, a contractual right to without prejudice privilege should not be upheld or enforced where it is invoked for an improper purpose. However, mere inconsistency in the absence of dishonesty will not do. By analogy with this line of authority, there is, to my mind, a powerful argument for saying that if a clear and unambiguous statement is made by one party in without prejudice correspondence, and the statement is acted on, and reasonably acted on, by the other party, an objection by the first party to the correspondence being put in evidence by the second party in order to justify the step taken by the second party would be plainly unconscionable and would not be upheld by the court. There's another reason for reaching that conclusion. In Tomlin, it was held that without prejudice correspondence could be looked at by the court to see if the negotiations therein resulted in a settlement. Although, of course, contract and estoppel are quite separate concepts, it appears to me logical and consistent that if without prejudice correspondence can be looked at to see if it gives rise to a contract, then such correspondence can also be looked at to see if it gives rise to an estoppel. However, I do not suggest that there is an absolute rule to that effect. So he is identifying there the availability in principle of without prejudice material coming into the trial process in support of an argument based on estoppel. And incidentally, I can just note in passing that he does that in part by analogy with one of the other established situations in which without prejudice material has been admitted, namely to prove the contract, which was the reference to Tomlin and Standard Telephones. I merely mention that because there is a suggestion in my learned friend's case that the court should not proceed by way of analogy, drawing information, so to speak, from other situations in which without prejudice material has been adduced. My learned friend says that analogies are not the way forward. We've seen both in relation to the Giovanna case, the ex parte Moreva application case, and this case, that the court does in turns proceed by way of analogy. But
Mr. Justice Neuberger actually equates it to two distinct exceptions, doesn't he? Because the first one, the unambiguous impropriety, he's saying really if you say you're going to do something and then you go back on it, that's unconscionable.
Yes, absolutely. And we would respectfully suggest that should be a matter of no surprise at all, because what we are dealing with is a privilege of excluding material, and privileges should not be allowed to be relied upon in front of the court in order to support unconscionable conduct. Estoppel is rooted in the concept of unconscionability, and therefore it should, quite obviously, we would submit, stand as a possible basis upon which without prejudice material can be adduced. That reasoning has been reflected since Hodgkinson was decided at higher levels in the Unilever case, which is back in Bundle 3 at tab 45. We see reference to it at, you may just remember, at 2444 E to F. It was Your Lordship's third illustration of one of the most important instances. Even if there's no concluded compromise, a clear statement which is made by one party to negotiations on which the other party is intended to act and does in fact act may be admissible as giving rise to an estoppel. And Your Lordship points out that wasn't disapproved in the Court of Appeal, and Your Lordship doesn't express any disapproval of it there. And then Lord Neuberger's judicial career was such that he could approve his own judgment when he reached the House of Lords in Foulet and Bossert, which is Bundle 2, tab 28. And the relevant passage is at paragraph 99. Where right at the end of paragraph 99, you'll see he refers to Hodgkinson, which involved the well-established exception of estoppel, as explained in Unilever.
Now well-established.
So there we are. It must be right, because he said so twice. So, my Lord, we are in the position in which there is good authority from first instance through the Court of Appeal to the House of Lords that in principle without prejudice material is admissible. And as I say, this is unsurprising. We would simply submit to your lordships that, given that the pleading of estoppel is one of the issues that is going to trial, and given that the question or the point of principle has been established that estoppels are capable of bringing into the trial process without prejudice material, it is simply premature at this stage to declare that this material is inadmissible in relation to this estoppel.
Suppose it were admissible on the estoppel point. What effect would that have on its admissibility? What effect, if any, would it have on its admissibility on the interpretation question?
Well, the effect would be that the respondent would be precluded from denying the assumed factual basis upon which the contract was agreed, even if it was untrue. So the value of estoppel is that even if it is not the case that the contracts were all sleeved, the parties proceeded on the assumed basis that it was, and so that then informs the interpretation of the contract. So
Sorry,
it feeds back.
I'm getting lost. So you're better off with an estoppel?
No. We are simply, we are entitled to rely on the estoppel in order to inform our interpretation of the contract, irrespective of whether the statement is true or not. If it was a true statement, it is necessarily part of the factual matrix. If it was an untrue statement, the respondents are stopped from saying it was untrue. So we just stay in the same position, namely, either the fact or the assumed fact.
And if it was a true statement, the statement being what?
The statement being that the contracts between TMT and Oceanbulk were sleeved, as at the date when the discussions of the settlement agreement were taking place.
Sleeved being evidence of, depends upon there being an agreement between the parties to this, between Oceanbulk and TNT or whatever they're called.
The fact that they were sleeved is part of the matrix then against which the interpretation
So that both parties know they were sleeved.
Yeah.
Yeah, but sorry, before you get to the estoppel, assume there it is, they say they're sleeved, you say, and all the earlier argument is that that itself is part of the factual matrix, don't you?
Yes.
Whether true or false?
We say the fact that it is said is part of the factual matrix.
Exactly, whether true or false.
Yes.
And it proves to be false. You say what, irrelevant?
Well, if it proves to be false, we say, well, you are stopped from relying on that.
No, but that's invoking estoppel. Before you get to estoppel, that's why I'm asking whether you're better off with estoppel. Just assume, forget estoppel.
Right.
And it proves not to be true. It's not true. Let's assume they can show it's not true. They weren't sleeved.
If they can show that it was not sleeved and we are unable to rely on estoppel, then I can see we will have some difficulty in establishing that there was part of the factual matrix was that they were sleeved, yes.
So you need both?
Well, we only need both if the statement was untrue.
You don't need both, do you? I mean, if parties enter into a contract under a misapprehension that something is the position, that shapes the meaning of their contract. It certainly shapes the level of damages they can claim. It's not a question of estoppel, it's just that is the foundation. That is what, that's the state of their knowledge.
So I was perhaps assuming too much. I was answering the question on the assumed basis that it was untrue and known to be untrue by Oceanbulk. But your lordship is right. If the position is simply it was said, and it turns out that the parties were mistaken, then yes, it is part of the factual matrix.
And if it was said that the person saying it was lying, it's still part of the factual matrix.
That it was said.
And it was said, and it's still what shapes their contract. I just wanted to put another point to you about your estoppel point. Are you, in the light of these cases, actually taking the right analogy? Because these cases concern a situation, unlike yours, where the conduct relied upon on the basis of the statement did not consist of entering into the settlement agreement. In the Miss Justice Neuberger's case, the conduct relied upon was conduct in not raising an issue in the litigation which followed because there wasn't a settlement agreement, right? Yeah. But here you say, I relied in entering into this settlement agreement upon this representation. Now, the true analogy is surely misrepresentation.
Yes.
Everybody accepts you can claim damages for misrepresentation. Estoppel is simply the other side of the coin. Instead of claiming damages, you're relying on the representation to bar the maker of the representation from asserting a fact.
Yes.
Which must be taken to be true. If you can rely on misrepresentation, you can certainly, one would have thought, rely on estoppel.
Lord, yes.
In this case.
That may, well, I'm grateful. That may well be
I have some
a better
difficulty seeing
analogy.
how the estoppel of the fact works in a situation like this, where parties agree that they will try to unscramble a tripartite what is has been stated to be a tripartite contractual relationship, when actually it's a bilateral relationship. So you say, well, you're stopped from denying that it's tripartite, but how does that actually work in practice? And as a contract has been concluded on the basis of a statement which is untrue, you say, well, that's not the contract I entered into. I didn't agree that I would unscramble an agreement that was then bilateral. Or you say there was misrepresentation which induced me to agree to this.
Yes.
Is that the way it works?
Well,
I don't see how you can proceed to assess damages on the premise of something which isn't the true situation. I can say they can't recover more than they would have recovered.
Yes. Well, Lord, that somewhat slides into the question which we have labelled remoteness. Yes. The pleading of estoppel is directed towards what the rules of the game are going to be for interpreting the contract as to what it actually means, and that will then dictate who, if either, is in breach of the agreement. The point your Lordship just made goes, I think, more towards the assessment of damages, and that is the second subsidiary argument that we are seeking to run. That is pleaded in, just so that you've got it in front of you, it's paragraph 27 to little 3 of the same pleading, which is page 108. Little 3 at the top of the page, it's denied that Oceanbulk is entitled to claim the loss and damage it claims, as pleaded in paragraph 18 above, clause 5 of the settlement agreement, was agreed in reliance upon and on the basis of Mr. Papps's representation or representations on behalf of Oceanbulk, and the parties understood that the swap agreements between Oceanbulk and the defendants were sleeved transactions with the Oceanbulk opposite market positions. Accordingly, it was or should have been in the parties' reasonable contemplation that closing out the 2008 FFAs left the risk of the market rising and the benefit of the market falling on the defendants, but no risk or benefit on Oceanbulk, because Oceanbulk was, until completion of the closing out process, protected by Oceanbulk's opposite market positions. Accordingly, the loss which Oceanbulk seeks to claim in paragraphs 26 and 27 is too remote and or is not loss for which the defendants had assumed responsibility. Now, we have really very little to add to what we say in the printed case in relation to this. By way of very brief summary, we say simply that contractual liability for damages depends upon the intention of the parties, objectively ascertained because all contractual liability is voluntarily undertaken. Secondly, that a type or kind of loss is not too remote a consequence of a breach of contract if at the time of contracting it was within the parties' reasonable contemplation as a not unlikely result of that breach. And thirdly, that the scope of loss that is within the parties' reasonable contemplation is ascertained primarily by reference to facts which the law imputes to the parties, but it may be extended or restricted by their actual knowledge. And so the question of actual knowledge is going to be a live issue in relation to remoteness. There has been no attempt to strike out the pleading in relation to remoteness. So again, the only question is as to the evidence that is admissible in relation to this issue. And so far as that is concerned, what the Court of Appeal appear to have said is, well, we've reached the view we have on admissibility in relation to interpretation, and it therefore follows, they said, that the evidence can't be admissible in relation to remoteness because they say in paragraph 33 that the question of quantification is of lesser importance. And we submit that that is simply not an appropriate way of characterising the position. Paragraph 33, Lord Justice Longmore says, page 15 of the bundle. It's dealt with in one paragraph. He says that the same sort of considerations apply to the question of remoteness. If the privilege of the without prejudice umbrella means that arguments about construction can't be employed, I can't see how such arguments can be employed on the different but essentially lesser question of remoteness of damage. If I understood the argument correctly, TMT wished to say that although they acted in breach of contract in refusing to cooperate and closing out their bilateral positions, they can only be liable to the extent that the transactions were not sleeved, but that's really the same argument as the argument on construction. Lord, we submit that there is an error in that in simply regarding the question of the assessment of damages as being somehow a lesser question than the question of interpretation. It is a matter of the highest importance in most cases, and perhaps greater importance in the sense that a party may feel entirely indifferent to the prospect of being found technically in breach of a contract if the damages are negligible. But obviously will feel considerably stronger if the damages are $105 million, as they are thought to be in this case. So to suggest that quantification is in a different order of importance from the question of liability.
Surely they're right, aren't they, that you can't be any better off? In other words, it would be very strange if something were admissible on remoteness and not on interpretation, or vice versa. So, I mean, I think all the Court of Appeal was saying is it doesn't add anything. This.
Lord, it would be possible, we submit, to reach the conclusion that material was admissible on remoteness, but not in relation to interpretation, because they are entirely freestanding questions. I being realistic, would recognise that the two are likely to go hand in hand in individual cases. But the question in each situation is, well, where first of all, they really are the same two questions as in relation to interpretation, the admissibility in relation to interpretation. First is, well, is the admission of evidence in relation to remoteness pursuing the same public interest and therefore wholly unobjectionable in relation to the without prejudice privilege? To which we would submit that the answer is yes, because if exactly really for the same kind of reasons as we've given in relation to the first main argument, which is that if parties who are contemplating negotiations know that different rules would be applied in ascertaining loss if they entered into without prejudice negotiations which led to a contract from those which apply in relation to open negotiations which then lead to a contract, then that would discourage without prejudice negotiations, because they would know that the law is that what they knew, what was in their reasonable contemplation by reference to actual knowledge, would be discounted in relation to without prejudice contracts. And so there is that separate argument, and then there is the question of, well, if there is a competition, which way does the balance fall? And as I say, in relation to that, we submit that the two questions of interpretation and remoteness are freestanding as a matter of legal concept, but as I say, being realistic, I think we would have to accept that the two results are likely to follow hand in hand.
And on the other side, it's not suggested, is it, that if you're right on the first point, it's not suggested, is it, that they can succeed on the remoteness or estoppel points?
Lord, I don't understand that it is. We will hear from my learned friend if I'm wrong on that. Could I just take one moment to discuss one point? Lords, it's been pointed out quite rightly that obviously the question whether or not the contracts between TMT and Oceanbulk remained sleeved as at the date when the settlement agreement was being negotiated was a fact peculiarly within the knowledge of Oceanbulk. And so we were in the position necessarily of having to rely on what we were being told in relation to that. And so I may have said and would wish to retract any concession that if it proved to be untrue, then that would make our position more difficult, because the question whether it is true or not is, as I say, peculiarly within the knowledge of Oceanbulk, and so we have to rely on what they say. And so, as my Lord Mance mentioned, if it is said, then it is part of the factual matrix.
And the whole point of estoppel is actually that it makes it true.
Exactly. Lord, unless there are any other points.
And is the representation said to be that all the contracts were sleeved?
My Lord, the representations evolve in those 4 sub-paragraphs I took you to. The 2 that are in dispute, and perhaps one of the most important, is the one at the top of page 99, because it actually names the figure. And what matters, if you look at the top of page 99, this is the one that perhaps prompted the judge at first instance to say that this material could have a serious probative weight, is that the email of the 10th of June from Mr. Pappas to Mr. Sue asserted that Oceanbulk had to pay $40.5 million, which is the figure that TMT on that date owes to Oceanbulk. So if that statement is true, what he is saying is, yes, they were all sleeved.
If they were all sleeved, I mean, does it follow that actually they couldn't metal less to Oceanbulk when it all was resolved?
Exactly.
So why?
They are protected.
But if they're protected, I mean, why do they bother with this clause 5 at all?
Presumably clause 5 is in TMT's interest to try and get out of this onerous exposure.
Yeah. Lords, unless there are any other questions.
I was just trying to think of a simple example of this kind of estoppel situation. Personal injury action, you have a collision with another car, and the driver of the other car is rendered permanently immobile. You're then discussing settling the case, and you say, well, he's looking at his loss of earnings. What was he earning? He was earning £15,000 a year. You say, right, we'll settle. You then say they can't turn around and say, well, actually, he settled on terms that you pay 60% of his loss of earnings, and he was actually earning 50,000 a year.
Yeah.
You simply is stopped from asserting
Yes.
that he was earning anything more than 15,000.
Yeah. That would be another situation.
Yes. Yeah.
Although, no doubt, thought will be given as to whether misrepresentation is a better way of putting it rather than estoppel or an additional way of
That's the
putting
scenario, really.
it. Yeah, exactly. Lord Ness,
Yes, thank you.
any other questions? Those are our submissions in support of the appeal.
Mr. Lieberton? Yes, Mr. Chairman.
So I'm going to start, if I may, with some brief submissions on the facts.
On the what?
On the facts. Not because there will be any great enthusiasm on your Lordship's part to get into the arguments of construction, but for two reasons. One, because there is an alternative side to some of the things that have been said, and I just want to make a couple of brief points. But secondly, because from time to time, in my own friend's submissions, he approaches this question before your Lordships on the basis that this is a balancing exercise in a fairly fact-specific context. At times, my own friend puts the submissions to your Lordships on the basis that, well, in any factual matrix situation, anyone who alleges anything which they consider to be relevant as a background fact can be admitted in evidence, notwithstanding the without prejudice rule, and we can just deal with it as a matter of principle. But at times, we get into the facts, we get into 7 relevant considerations which he piles one on the other and says, well, putting them all together, it shows that in this case, if not in any other case, it's right that the balancing exercise goes in a particular way. So I do just want to start very briefly, if I may, by addressing some points on the facts. I will then address your Lordships on the without prejudice rule, both as a matter of public policy and also something we haven't heard much about with respect to the contractual basis for the privilege. And then I will deal with each of the alleged exceptions in turn, concentrating on factual matrix, because I recognise that if we lose on factual matrix, that's the end of the debate, answering my Lord Clark's question. I shall also be submitting to your Lordships that if we win on factual matrix, that there isn't a proper basis for creating such an exception, that the estoppel argument, which I will obviously have to analyse, and the remoteness argument do not get my learned friends home if they fail on the principal argument. So I shall concentrate my fire on factual matrix. My Lords, turning briefly to the facts, the relevant dispute concerns the construction of a written settlement agreement. It's at page 73 in the appendix. Your Lordships have glanced at it. This is a case in which, after negotiations which were explicitly without prejudice, the epithet or the rubric without prejudice was put on correspondence passing between the solicitors when they exchanged proposed drafts of settlement, and was then followed by an unscripted 2-day meeting to discuss the terms of the settlement in June of 2008. This is a case in which the parties drew up a written settlement agreement which was intended to reflect their agreement. It was signed, and there is no suggestion, no allegation in this case, that something has gone wrong with the drafting of this written contract. This is not a case, and I will deal with this subject later on in my submissions, but this is not a case in which rectification is sought. The only issue concerns the interpretation of the written contract. The underlying dispute which had led to the negotiations and the settlement can be shortly stated. It is summarised in the agreed statement of facts in paragraphs, just for your Lordship's reference, it is paragraphs 6 and onwards. But it can be summarised in this way. By May of 2008, under these FFA contracts, my clients were already owed something of the nature of $40 million. They were going to be owed, so everyone confidently expected, a further $30 million by the end of the next month. And had we declared an event of default under the master agreement governing all the FFAs, as we said and say we would have been entitled to, although that is disputed on the pleadings, we would have been entitled to crystallise all the 63 or 65 odd FFAs out there, and we would have been owed, on our case, something like 300 to 400 million US dollars. So the context in which this settlement agreement was entered into was that the defendants, TMT, were staring down the barrel of a gun, not just as regards my clients, but as regards other traders out there with whom they had done similar trades. They had called the market wrong, and there was, on any view, a very, very serious risk of insolvency. And it was in that context that we negotiated and resolved a settlement agreement with a view to, as it were, compromising our existing claims and also addressing the prospective claims that were liable to arise in the future. But as is clear from the agreement, and if your lordships would turn to it briefly at pages 73 to 74 of the appendix, this was very much an agreement made with one eye to the possibility that further disputes would ensue. Because faced with the FFAs and the prospective insolvency of TMT, there are provisions in this contract, even if one ignores other evidence which stands outside it, but there are provisions in this contract which make it plain that the parties had an eye to the possibility that all would not go well in the future. My Lords, very briefly, skimming through the agreement, Clause 1 was for the transfer of some shares, which we don't need to worry about, although that in itself has given rise to a subsequent dispute which is in issue. Clause 3 provided that the TMT interests would transfer some bare ownership in a couple of vessels to us for the consideration of $1 per vessel. And then over the page, at the top of page 74, the arrangement was that the interests would be transferred back to TMT for $1 per vessel, provided always that TMT's interests to us for 2008 and 2009 had been discharged in full or alternative security had been agreed. Clause 5, which is the critical question for present purposes, is a clause to which I will come back in a moment. Clause 6 provided for a running account with monthly payments to be provided to us, and at the bottom of Clause 6, your Lordships will see in subparagraph E, in the event of non-payment of one of the instalments, OBST, my clients, shall have the right to call default on TMT interests FFAs. Clause 7, dealing with open positions under 2009 contracts, provided that they were to be invoiced and settled in accordance.
So there were a whole series of contracts running on till when?
There were approximately 67 contracts for 2008. There were a series of contracts for 2009, my Lord. The scheme of this arrangement was that the 2008 contracts were going to be dealt with as per Clause 5, which I'll come back to in a moment. They were going to be crystallised or closed out against the market, the critical phrase for present purposes. The 2009 contracts were to be left open. They were to be operated as normal, save that, see Clause 7, they would be subject to any set-off in respect of 2008 for sums that may be due. And in fact, there is a separate action concerning the 2009 FFAs proceeding before the Commercial Court in which there is an issue as to whether we can set off against the 2009 contracts the sums which we say are due to us under this arrangement. My Lord, Clause 7 provides also that in the event that TMT interests are in default of payment under the 2009 FFAs, OBST shall be entitled to terminate the bareboat charters. Clause 8 requires the execution of some formal documents at the top of the next page, failing which OBST shall be fully entitled to proceed in whatever way it chooses in respect of its FFAs with TMT interests. And then Clause 9 contains a provision for English law and English jurisdiction to resolve disputes. So it would be wrong, as is obvious from that agreement itself, let alone any other material, it would be wrong to assume that the parties envisaged when they went into this arrangement that this was going to be the final chapter, as it were, in their commercial relationships, not just generally, but in relation to the very matters which were at the heart of the dispute which preceded the settlement agreement, and which is at the very heart of Clause 5 of the settlement agreement as well, in relation to TMT's performance of its financial obligations under the 2008 FFAs. So this isn't one of those cases where a chapter is, as it were, being closed, and then something happens after the event, perhaps in a different jurisdiction, perhaps unforeseen at the time, a completely different dispute, divorced from what has gone before. My Lords, the particular dispute, as your Lordships have heard, concerns the issue of construction surrounding a part, and only a part, of Clause 5 of the agreement. What is meant by the words, will cooperate to close out the balance of 50% of the open FFAs for 2008 against the market on the best terms achievable by the 15th of August 2008. Both sides have their respective positions on that. It will not assist your Lordships, really, for me to develop the points on that. My learned friend has correctly said that the issue between the two parties is whether this envisages a trilateral or triangular process of closing out or cooperation to close out, or, as my clients say, and as we will say at trial, a bilateral closing out between the two parties to the open FFAs. Without going into it, there are difficulties, we say, in the trilateral approach to construction. Firstly, for reasons which flickered earlier in the argument, which is how on earth does this trilateral process of cooperation actually work out in practice? It's no answer with respect to say, well, these are sleeve transactions, or said to be sleeve transactions, because as the aggrieved statement of facts makes plain, the whole point about sleeve transactions is that when there are sleeve transactions, that the third party, the counterparty, doesn't know about the presence or the identity or the involvement of the person on this hypothesis being TMT, who have requested my clients on this hypothesis to sleeve on their behalf, because either the third party won't deal with Mr. Nobby Sue of TMT, or because TMT doesn't want it to be known that the market is being moved by him. So there's that problem. There's also the problem, of my learned friend's explanation of how it works, of a process involving going to somebody else, closing out at a certain price, and then on this hypothesis, having to go back to TMT, by which time the market may have moved in one direction or the other, and saying, well, will you please now close with us? But these are, frankly, debates for another day, and they will be determined by the court on the basis of the language of the clause and with the assistance of expert evidence, both sides having experts to assist the court on the way in which the FFA market works and concepts such as crystallisation, closing out, and the like.
Can I just answer that? The fact of the matter is that your clients and Clause 5 read the market right, in the sense that it had gone up against TNT,
Yes.
but they predicted that it was going to go down, so you needed to close those positions out before they switched the other way around and put you in deficit. And it did switch. It went severely the other way around, and TNT say that you actually owe them money.
Yes. Yes, Lord.
And they say you owe money not just in this action, as it were, but also in relation to 2009.
Well,
because the market has gone in their favour by then.
They say in relation to 2009, and 2009 was left open, but 2008 is the particularly acute one.
Yes.
Because whoever's right, these contracts were not closed out. And we say it's bilateral, they should have been closed out.
And they weren't sleeved, so you weren't protected.
Can I
well, they may not have been.
May I leave sleeve just to one side for a moment? I'm going to come to sleeve, if I may, my lord. But just answering the question of our position between ourselves and TMT for a moment, they should have been closed. If they had been closed, then there would have been a significant sum payable to us of the order of $45 to $50 million. They were left open in breach of contract. Now, it may be, on my friend's case, that we failed to cooperate doing the right thing, but they were left open in breach of contract by someone, as a result of which the market has dramatically collapsed at the tail end of 2008, and we are now said to owe them 80, 90 million, or whatever the right figure is, so that there's a swing, if you like, between the respective positions of 130 million.
Is there any explanation as to why, since you accurately predicted that the market was going to fall, and since we almost hypothesized that you weren't protected by sleeve contracts, you didn't actually mitigate your loss by selling when the market was high, back to back.
Can I now deal with the sleeved aspect of this to answer your question? Because it's in a sense it's more complex, but in another sense it's rather simpler than the apparent divide between the parties. The issue between the parties, as a matter of fact, is that our pleaded case in the reply is that some of the transactions were sleeved. Most of them were not sleeved, but were the subject of what I'm going to describe as opposing market positions, but they may have been opposing market positions on different terms. But they weren't sleeved. I mean, the figures don't matter, but the factual battleground between the parties, in fact, is extremely narrow. They say that we led them to believe that most of these contracts, or substantially all of these contracts, or indeed all of these contracts, depending which formulation, whichever email or paragraph of the pleading you want to take, were sleeved. We recognise that some of them were sleeved, not the majority. The majority of them had the results of independent hedging or independent speculation by my clients who hedged the market. So
what's the difference between hedging and sleeving?
The definition of sleeving, my lord, is a very precise one, which has been recorded in paragraph 16 of the agreed statement of facts.
Paragraph 3.
Paragraph 16, my lord.
16,
page 5 of the core volume. It's a very, very precise definition, and it's paragraph 16. Sleeving is an arrangement by which one party, party B, and my lords, we'll call those OBST, my clients, will, at the request of another party, party A, and we'll call that TMT, enter into a specific FFA trade with a third party, party C, let's call them cargo.
So the sleeving involves an agreement between these parties, whereas hedging doesn't.
Yes. Independent speculation. And one might say, and I hear what my learned friend says in one of his parting shots, where he says, well, the key is, have they remained sleeved once they were entered into? Because the key, of course, as your lordship has seen from the definition, is they don't remain sleeved. But one might have thought, with the greatest of respect, that if the definition of a sleeved transaction is one entered into at the request of, in this case, TMT would know how many transactions had been entered into originally on that basis. Now, again, these are matters, no doubt, for another day, but, and I've still got a question from my Lord Romance to answer, but just within a very narrow confine, the battleground between the two parties on the facts is actually quite a narrow one. Are they all sleeved? Are they mostly sleeved? Or are there some sleeved? And are some the subject of independent speculation or hedging? Now, to answer the separate question about, well, what happens in relation to these other contracts in the sight of what's going to happen to the market, these are independent contracts, whether they are sleeved transactions or not. And that indeed is the agreed statement of facts. So the fact that they were sleeve transactions means that once they're, if that's what they are, means that once they're entered into, my clients can decide to do what they like with them. And ditto as regards the contracts of independent speculation. And what actually happened in this case is that my clients left a lot of these contracts, their counterparty contracts, open, as they were perfectly entitled to do, as a result of their own independent speculation. And they were entitled to do so whether or not those contracts were sleeved or simply the product of hedging. And our position is, as a matter of our claim for damages for breach of Clause 5, doesn't actually matter at all whether these contracts are sleeved, mostly sleeved, partly sleeved and partly the product of independent hedging transactions or not. You agreed with us that you would cooperate to close out our bilateral positions. If you had done so, instead of us owing you all this huge sum when the market fell, you would have paid us, or owed us, 49, 50 million, or whatever the right figure is.
So the issues in this appeal are really neither here nor there, then?
Well, I have to say, with great respect, my lord, there's a considerable element of force in that, because my submission has been all the way through this interlocutory battle, and is a game before your lordships, that this attempt to elevate representations which either were made or were said to be made as to whether a transaction was sleeved or not, or whether they all were sleeved or mostly were sleeved, on our case, it is a complete and utter red herring. Now,
it can't be in relation to sleeves, can it? Because if the whole essence of sleeved is that you've entered into the contract at the request of TNT, perhaps because TNT couldn't deal direct, then one would have thought that the existence of the contract was, on its face, quite material to the scope of the liabilities under your contract with TNT. But can I just put a second question? My actual question, which I think is not really worth carrying very far, was this, that assume you're right and you do forget all about the sleeved and back-to-back contracts. I mean, the fact remains that on your analysis, TNT defaulted,
yes,
and you owed on the face of it. This is a market. You can buy back-to-back contracts, presumably. Why, on the default, didn't you lay off your position on the market? Forget about whether you'd already done that. Lay it off by fresh contracts and protect it. Instead, you simply appear to have suffered a $130 million loss turnaround in the market.
Well,
I mean, it's only a question of matter of interest. Have I understood the parameters of the likely issues?
There is a pleaded allegation of a failure to mitigate to precisely that effect. That is one of the issues on the pleadings. Our answer will be, my lord, that what we do vis-à-vis independent third parties is a matter for us. It's a matter of our independent speculation. And if, as a result of your breach of contract, you haven't closed out the positions,
yes,
we've suffered a loss vis-à-vis you. Now, I can see that there is an issue about mitigation. We will say it's wrong. But, my lords, and the first point that your lordship made about sleeve being relevant to the loss that we suffer and can claim under the contract vis-à-vis TMT, we say that that's a wrong way of analysing a sleeve transaction, which by definition and by agreement allows us to proceed independently vis-à-vis the third party once we have entered into this contract on their behalf. This isn't an agency relationship or anything of that nature. Now, my lords, that's the background, and in a sense, your lordships, no doubt, with a sigh of relief, do not need to confront what this contract actually means. But it is relevant to the background in which the issue of principle arises. What is said in this case, as your lordships know, coming closer to home, is that in support of an allegation that closing out or cooperating to close out the open FFAs against the market means a trilateral arrangement, the defendants wish to rely on representations to the effect that the contracts were sleeved contracts. And your lordships have seen this, it's set out in the pleadings at pages 98 to 99 of the appendix. And if one is considering for a moment the particular facts of this case, there is no issue that my learned friends' clients are entitled to rely on the open email of the 1st of June, which is at page 98 of the appendix, where there is an express statement for what it is worth. This is page 98 of the appendix, paragraph 18.1, little Roman 1, subparagraph 1. There's an email which says, from my clients, most of this position is in any case due to the sleeves we did for you when you asked us in the past in order to assist. And there's also an open meeting on the 5th of June 2008 when there's a reference again to a statement that we had sleeved TMT's trading at Mr. Sue's request. So if, and it's never quite clear to what extent this is at the forefront of the TMT argument, but if one is into a fact-specific balancing exercise as to whether the interests of justice require the overriding of a without prejudice privilege in this case, And that's obviously not the primary way in which my learned friend puts his case. But if ever one gets to a stage where one is actually drilling down to the facts of this case, this is a case where, for what it is worth, and it's our submission it's not worth much, but that's obviously tendentious, for what it is worth, there are open communications which enable my learned friends to make the points on construction without overriding the privilege.
I'm sorry, I don't quite understand why, merely because they weren't specifically said to be without prejudice. They were obviously part of an ongoing series of negotiations. Why don't they attract privilege anyway?
Because the first two occasions, my lord, that's the email of the 1st of June and the first meeting, were really before settlement negotiations started.
I see.
And that's it's common ground. It's not, and it's never been suggested that the meeting of the 5th of June was a privileged occasion.
I see.
So that's the answer to my lord's
So
question.
I'm wrong to get the impression that they were in negotiations from the opening words of paragraph 1811.
If I may say so, my lord, it is a fair assumption to make, but the common ground between the parties, for your lordship's reference in the judgment of Mr. Justice Andrew Smith, at paragraph 15 on page 29, paragraph 15 at page 29, that meeting on the 5th of June, about 4 lines into paragraph 15, was described as a private commercial meeting to discuss payment.
This is all very mystifying, Mr. Sheff. You seem to be saying that these 2 paragraphs are quite sufficient for them if they've got a case. So why have you gone to all the trouble of trying to strike them out? The rest of the paragraphs, there's a bit of a mystery.
I could turn that round, of course, with respect, my lord.
Well, there's an element of it too, brutality.
But the answer to your lordship's question is because the defendants want to lift the lid on the without prejudice negotiations. And you haven't been given the witness evidence, and I'm going to develop some of the difficulties that may arise if without prejudice is breached in due course. But it may come as no surprise to your lordships to know that the witness evidence which is put in on the without prejudice 2-day meeting on the 19th and 20th of June goes rather further than simply to evidence the narrow representations that are put into play in this pleading. And that's an inevitable consequence, in a sense, of trying to, as it were, dissect, to use that word which my Lord Walker used in Unilever, dissect a communication and try and drill down and pick out a couple of little nuggets, as they are supposed to be, from the privilege negotiations. So, my Lord, we're here to debate whether of course, without prejudice, privilege can be breached in these circumstances. The answer is that, really, there is an attempt to get disclosure in relation to the unscripted meetings of the 19th and 20th of June. There's an attempt to lead evidence, which at the moment, in a sense, has been put in a brown envelope pending this appeal in relation to that meeting, which is not and cannot, by definition, be hermetically sealed. So that's the background. My Lord, my Lords, the context then of this debate and this issue of principle that arises is whether the 2 without prejudice communications, one being an email, one being an unscripted meeting or occasion for communications, can be put in evidence. The actual 3rd email, which your lordships haven't seen, it's referred to in subparagraph 3, which has been held to be privileged, is page 72 in the appendix. And it's worth just, if I may say so, looking at that, just to identify the sort of exercise that we are engaged in this case. We obviously don't have the benefit of a script for the 2-day meeting, but we do have this email, which has been held by Mr. Justice Andrew Smith, at paragraph 20 of his judgment, to be privileged, to be the subject, albeit not expressly headed, without prejudice. This email, it is common ground, is protected by without prejudice privilege. And under the heading of FFA debt, your lordships will see, I understand from our lawyers, this is written by my client to TMT, or Mr. Nobu Su of TMT. I understand from our lawyers that you said that you would not like to transfer the 6 million of your Oceanbulk shares to me, but only to pledge them as we discussed. Let me, however, expand on this issue so that you can understand my position. The spirit of our discussion was that A, you will definitely secure me for the cash that you have not paid for the May 2008 FFA contracts and not be able to pay for the June 2008 FFA contracts, and B, that you promise not to dispose of the balance of your Oceanbulk shares so that you're able to cover me for subsequent payment difficulties. This was the essence of what we agreed upon as good friends, and then 40.5 million was paid on your behalf against zero receipts. Do not forget that you only informed me 1 day prior to due payments of your inability to perform, and that OBST was therefore put in a huge cash flow strain in order to meet its obligations. And then he goes on to discuss the problem that arises is that the pledge is not particularly good security. He wants a transfer of shares, and he discusses the detail of that. And at the end of that first main topic, please confirm that you're therefore okay with this arrangement and that the lawyers can proceed on that basis. Now, what is being said on this appeal, and one can see it in a sense in black and white by reference to this email, but one can't by definition do it for the unscripted discussions over the 2 days that they took place, is that although the parties have agreed to negotiate without prejudice and that this email is protected by without prejudice privilege, one is entitled to dissect this email and extract from it the words which are sounded upon by TMT in this case. This was the essence of what we agreed upon as good friends, and then 40.5 million was paid on your behalf against zero receipts. And to divorce that from the context in which this discussion was taking place, the discussion about the unpaid debts, the negotiations that were taking place about the payment for the May and the June 2008 contracts. And in a sense, one can compound this problem substantially for obvious reasons when we get to the unscripted discussions, because the exercise that is proposed is that one takes those discussions, one recognises that they are without prejudice, but one can say, well, because we discern in those discussions something which we, TMT, say to be relevant, and we have to proceed on the basis that it is therefore arguably relevant to the construction of the contract, we can drill down, we can extract that, take it out of its without prejudice context, and we can lead evidence on that. And, my lords, we say, firstly, that that is a completely impermissible approach to without prejudice privilege for reasons that I will address your lordships on. But secondly, if it is to be suggested, and this, in a sense, is why I've just opened on this basis, if it is to be suggested that, as is said, for example, in paragraph 47 of my friend's case, that there is some sort of gross injustice here if the privilege is not breached for the purpose for which it is contending, we say that that is just not the case. And this is, at best, a background fact, if it be a background fact, of the most marginal relevance to a question of construction, in relation to which these defendants have open communications which they can rely upon in any event. Now, my lords, that's all I wanted to say about the...
I mean, I thought we were here on a point of principle. Well, you put it on, very narrowly the facts of the case. I mean, isn't it capable of being answered yes or no? Is a without prejudice communication, which is ex hypothesi, capable of being relevant, admissible in evidence, as part of the background, the matrix of facts against which, therefore, to construe the contract?
No, I accept that, and that is primarily what we are here for. But as I say, there are echoes, and one finds them in the written case. And there was a certain element of balancing the 7 factors or the 5 factors or whatever they are on a more fact-specific basis. In certainly my own friend's second submission, which he advanced before your lordships today, to say that it's a rather more fact-specific basis. My primary submission to your lordships is, and I've developed this in a moment at some length, is that as a matter of principle, you do not create an exception for factual matrix material. But if it is to be suggested, well, maybe it's not an absolute rule and one has to drill down and look at the particular context, if that is in any state of play, at the heart of even an alternative submission from my own friend, we say it would be unfounded. So with respect, my Lord, I agree that there is a fundamental point of principle which I now need to deal with.
Because these points you've been making would have been equally valid if all the negotiations had not been without prejudice. You'd still say, this is going to be a very unsatisfactory exercise. But that's an argument against the admissibility of this material per se, not an argument against the scope of the privilege.
I would, without derogating, my Lord, from the primary position, which is that there is the point of principle to address, the answer is yes, I would have all those points on what I would call Chartbrook admissibility, general factual matrix admissibility. But insofar as the question of whether or not broaching or overriding the privilege requires a more fact-specific, case-sensitive approach to a case, then I would answer, my Lord, by saying, well, it could be relevant if one were tempted to go down that road to consider the fact that there's no injustice in someone being held to a privilege in circumstances where, for example, the material is available on an open basis. But that is by the by, that is a fallback position.
I don't really think that Mr. Crowe did argue for a fact-specific analysis like that. And indeed, I can't see how it would be easy to do so.
Well,
I mean, what he addressed was first, in his second line of submissions, was the possibility that one might regard two principles as being in competition, but that's rather different.
I accept that, my Lord. There are passages in the case. There is, for example, paragraph 47 of the case, which refers to this, or makes the suggestion that there is a gross injustice. Those are my learned friend's words. 47E Roman 4 of the case. A gross injustice to the appellants in this case. Insofar as there's any flicker of that, that is why I make the points that I do. My Lords, turning to the without prejudice rule, a fundamental aspect of this issue of principle, and one which, with respect, my own friend is, if not silent on, fairly circumspect, is that these parties, like many parties, have agreed to negotiate on a without prejudice basis. It's all very well to start with propositions about relevant evidence, about principles of construction, none of which are in dispute, to say that in principle relevant evidence should be admitted. But where the parties have expressly agreed to negotiate on a without prejudice basis, then the without prejudice rule or privilege comes into play. And there is criticism, as your lordships will have seen, in the case, although my learned friend didn't make the point orally, that the Court of Appeal, in a sense, started from the wrong place. That's paragraph 12 of my learned friend's case. That they should have, as it were, required us to justify the exclusion of the evidence, rather than required the defendants to justify why the without prejudice rule does not apply. And we say, with respect, that the Court of Appeal got the starting point absolutely right. We say that, and I'll develop this, that where parties negotiate without prejudice, and I am, for these purposes, leaving aside the use of the label without prejudice in a non-settlement context. I mean, the point which my Lord Mads made in Bradford and Bingley doesn't arise in this context of inappropriate application of the rubric. But where parties negotiate without prejudice, then a protection is afforded to all their communications, save with limited exceptions, which I will come on to, and that protection is afforded both as a matter of public policy, but also as a matter of the express or the implied agreement of the parties in agreeing to negotiate on a without prejudice basis. Now, my primary submission to your lordships is going to be that this is not a case where the distinction between public policy and contract matters, because my submission to your lordship will be that as a matter of the public policy rationale, there is no ground for creating an exception for factual matrix. But what your lordships will have detected, principally from my learned friend's first submission, is an attempt to say to your lordship, well, if we TMT can persuade your lordships that in fact admitting factual matrix evidence is consistent with the object of promoting settlement, is not inconsistent with the object of promoting settlement, it's almost as if one can say, snap, that's the end of the exercise. We, TMT, get the evidence in. And that analysis ignores the fact that the parties have agreed to negotiate without prejudice. One has to consider what it is that the parties envisaged by an agreement to negotiate without prejudice. And in the normal course of events, I would be submitting to your lordships that the public policy rationale and the implied contract rationale would be expected to go hand in glove. Indeed, it would be desirable that they should go hand in glove. It wouldn't be particularly desirable to have different exceptions, different scopes of particular exceptions, depending upon whether one had a two-party or a three-party situation, or whether one did or didn't use expressly or impliedly the words without prejudice. But one has to be wary about accepting my learned friend's invocation all the time, an exclusive invocation of public policy, that one is not at the same time imposing on the parties a bargain contrary to the one that they entered into and would have intended to enter into by using the rubric without prejudice.
Is it implicit in these submissions you're making that the reality is that the parties agreed not merely without prejudice, but subject to formal contract? Because if parties simply agree that they'll negotiate without prejudice, that opens the door to looking at what they've been saying to each other to see if a moment is reached at which there is a binding contract. If they say we'll negotiate without prejudice, and it's all anyway subject to a written contract, then there's a much stronger case for saying that it was implicit in the agreement that nobody could start raking around in the negotiations.
I'm going to have to come on and deal with questions about the survival of the privilege after the concluding the contract, which raises quite a fundamental point, as your lordships will have already observed. But my submission to your lordships, and I've set out a couple of citations, I think, in our case, at paragraphs, we deal with the agreement rationale at paragraphs 19 and onwards of the written case, page 11. And at paragraph 21, there's a citation from Cuts and Head, where we make the point, which is, I would respectfully submit, correct, that in most cases the parties simply agree to negotiate without prejudice. The scope of such an agreement is essentially a question of construction based on the usage of the profession. And there's a citation from Cuts, Lord Justice Oliver. In fact, that may be Lord Justice Fox, in fact, Lord Justice Fox. What meaning is given to the words without prejudice is a matter of interpretation which is capable of variation according to usage in the profession, and he makes the point that it's not going to be immutable. And then we give the references to two decisions, both of which in your lordship's bundles of authorities. One, Hodgkinson, which is Mr. Justice Newberger as he was, where he talks about the contractual basis of the privilege and characterises the agreement as one whereby the parties are agreeing that the contents of the correspondence will not be referred to in the proceedings in which they are engaged or which they contemplate. Accordingly, none of the contents of that correspondence may in general be referred to in the proceedings. And then in David Instance, which was a concluded settlement contract, and I can show your lordships that in due course, an agreement to negotiate without prejudice was characterised as an implied agreement. The documents would not be used in the current or any subsequent litigation between the same or related parties, subject to Unilever exceptions, which again I'll come to, and subject also to a point that Mr. Justice Lloyd made, that if the parties just came together in an unforeseen arrangement like a running down incident, then that might give rise to different considerations. But the answer to my Lord's question, Lord Phillips' question, is I would submit to your Lordships that in fact the nature of the agreement, which is that the parties are agreeing that what is said or written in without prejudice negotiations will not be used against them, either in those proceedings or subsequent proceedings, is actually entirely coextensive with the way in which the public policy principle is itself discussed.
So they're both subject to the exceptions. The only question is what the exceptions are.
I accept that. And indeed, under a public policy rationale, one is shaping the exceptions to reflect the court's view of public policy. Under the contractual rationale, one has to view the exceptions as being, in a sense, implied qualifications on the parties' agreement to negotiate without
but
prejudice.
they're the same. Whichever way you look at it, they're the same.
Yeah, they're the same, subject to perhaps some exceptions which don't fit easily into the public policy rationale, and the most notable of those was the one which arose in Walker and Wilshire, which was actually considered in Cuts. Perhaps I could just ask your Lordships, while we're on this, to go to Cuts and Head, which is volume 1 of the authorities bundle at tab 12, because in Cuts and Head, Lord Justice Oliver, tab 12, page 306, Lord Justice Oliver, halfway down the page between C to D, tab 12, page 306.
Well, we looked at this earlier.
Sorry, Lord.
We looked at this earlier.
I'm not sure that your Lordships actually went on or were taken on.
We weren't sure the bit you wanted.
No, thank you, my Lord. From letter E, having cited from Scott Paper from Mr. Justice Clawson, Lord Justice Oliver said this: if, however, the protection against disclosure rested solely upon a public policy to encourage out-of-court settlement of disputes, Walker and Wilshire is not readily intelligible. For although the court, and in particular Lord Justice Bowen, seems to be prepared to assume that an inability to refer to the correspondence on a question of costs after judgment would encourage settlement, it is difficult to see, if one thinks about it practically, how that could do so. As a practical matter, a consciousness of a risk as to costs if reasonable offers are refused can only encourage settlement, whilst on the other hand, it is hard to imagine anything more calculated to encourage obstinacy and unreasonableness than the comfortable knowledge that a litigant can refuse with impunity whatever may be offered to him, even if it is as much as or more than everything to which he is entitled in the action. The public policy justification, in truth, essentially rests on the desirability of preventing statements or offers made in the course of negotiations for settlement being brought before the court of trial as admissions on the question of liability. There's a reference to Jones and Foxall, and then over the page, 307A to B. Once, however, says Lord Justice Oliver, the trial of the issues in the action is at an end, and the matter of costs comes to be argued, this can have no further application, for there are no further issues of facts to be determined upon which admissions can be relevant. One is therefore compelled to seek some additional basis for the decision in Walker and Wilshire, and it is, as it seems to me, to be found in an implied agreement imported from the marking of a letter without prejudice that it shall not be referred to at all. This certainly derives some support from the judgment of Lord Justice Bowen, where Lord Justice Bowen says at 339, the agreement of the letter is without prejudice, ought, I think, to be carried out in its full integrity, and it carries out, it then cites Lord Justice Denning in Rabin and Mendoza, the last sentence of that citation being between F and G. Nevertheless, if documents come into being under an express, or I would add a tacit agreement, they should not be used to the prejudice of either party, an order for reduction will not be made. And then Lord Justice Oliver goes on to say, whatever may be the position of 1889, what may or may not happen as a matter of public policy, he then says, at letter H, if this is right, is there any logical reason why in appropriate circumstances the conventional meaning of the phrase shouldn't be modified so long as the intended modification is clearly expressed and brought to the intention of the recipient?
Of course, there was a case in which the offer, without prejudice offer, had been expressly been made without prejudice save as to costs.
This is the Cuts case, right?
Yes.
Yes, but Walker and Wilshire, there had been no such provision. In Walker and Wilshire, the material had been held inadmissible post-trial, which had in fact gone to trial and been the subject of a consent judgment from what one recollects. And Walker and Wilshire, without any such caveat on admissibility, had held the evidence inadmissible. And what Lord Justice Oliver is saying here is that that decision can only be justified or rationalised on the basis of implied contract. My Lords...
arising from the marking of the letter without prejudice.
Yes.
Does that mean if you had without prejudice negotiations which weren't marked without prejudice, you could refer to them on costs?
No, my Lord. I mean, in my submission, the answer to that is no, because what the courts have now said, as Your Lordship, I'm sure would have seen in other cases...
Yes, there's a wider rationale.
It can be expressly or implicitly the subject of without prejudice negotiations. But, my Lords, for present purposes, and I'm conscious of the hour, subsequent to Cuts and Head, perhaps I could just leave it on this basis, every leading decision on without prejudice privilege since Cuts and Head has recognised the twin rationale of the rule, i.e. based firstly on public policy, secondly implied contract or express contract. And if I can give Your Lordship some references without taking time up, if it's just convenient to do so, Lord Justice Hoffman in Muller, tab 27, page 77, Mr. Justice Neuberger in Hodgkinson, tab 22, page 190, my Lord Walker in Unilever, tab 45, at 2442, my Lord Brown in Bradford and Bingley, at paragraph 63, Bradford and Bingley is at tab 7, Lord Neuberger in Offalu, at paragraph 85, that is volume 2, page 28.
Sorry, tab?
Offalu, my Lords, which that is tab 28.
Yes.
Lord Neuberger at paragraph 85. My Lord Clark in Sumatra, the waiver case, which is tab 40, paragraph 37. Every case proceeds. And what, if I could just leave it on this passing shot, if I may, what has been said is that the public policy rationale may be the principal rationale. It may be that the role of contract, I think my Lord Rogers said this in Offalu, the role of contract is either to enlarge or to restrict the parameters that might otherwise apply. But one has to recognise that there are two rationales and not one. And indeed, Professor Wever at page 100 also recognises the role of contract to enlarge or restrict parameters which would otherwise apply. My Lords, I don't know if that is a convenient mode. I'm sorry, I've gone over 2 minutes.
Thank you very much.